Thanks very much, Elizabeth, and welcome to everybody, including those that fall under the Brighton and Hove Partners in Care banner. Apologies, my slide, the opening page of my slide missed you off, but everyone's very welcome. So, as Elizabeth said, I'm a partner at Hempsons. Hempsons really have always, for decades, specialised in health and social care work. A number of us do inquests and have been doing them for many years. Me personally, my background is, until more recently, it's been primarily in assisting doctors and dentists and other healthcare professionals. Some of that's defending regulatory allegations, some criminal, but I've always done inquests alongside that, and particularly more recently on behalf of some social care providers as well. So that's the introduction. Forgive me, I'm swapping between different screens. So if we could just move on to the next slide, there's a brief overview of what I'm intending to cover. I'm not sure, Elizabeth, whether you're able to, here we go. Yes. So yes, I'll look at what it may sound basic, but what inquests are and what their purpose is, put them into a little bit of context in terms of the social care provision background, social care providers, and obviously going to look at the kinds of issues that might arise for you as social care providers, and then move on to more practical things such as preparing the actual inquest itself. They're perhaps the main things. So what I was going to suggest is that unless you have a real burning question at the time, I'll hopefully have a bit of time at the end to deal with some questions, because I may skim over some of the earlier slides relatively quickly, knowing that ultimately I think that the more practical ones will ultimately be of more use to you, and they come a little bit later. So that's what we're going to cover. I think the next two slides can probably be skimmed over relatively quickly, but if we can just move onto that one, just really to make the point that we've probably all seen press coverage of inquests and inquests including social care providers, and probably increasingly so in recent years, as inquests I think seem to have more press coverage really over the last 5 or 10 years. And yeah, please, if we could move on one more, and then I'll come to what an inquest actually is. So an inquest has a particular purpose, and that purpose is to answer 4 questions, or for the coroner ultimately to answer 4 questions. And those are who died, where, when, and how. And in most inquests, who died, where, and when is fairly straightforward. Not always, but usually most of the evidence is all about how a person came by their death. They are very factual. So an inquest by its nature is a fact-finding inquiry, and that makes it quite different from other court proceedings. So it is a court process. If you attend an inquest, you're attending a court, but it's quite different from the kinds of courts you're more likely to see on TV, such as criminal courts in particular, where you have sides who are against each other, defendants. It's about blame and guilt. Inquests are not about blame or guilt, even though sometimes the findings might be a little critical. But the rules actually preclude the coroner from coming to a conclusion that implies civil or criminal liability. And they're certainly not meant to be about blame. There aren't sides either, which, as we'll come to shortly, means that if you attend an inquest, you're likely to attend either as a witness or potentially what's called an interested person, which means you have an interest in the outcome. But there's no defendants and claimants, and the language is intentional that you have interested persons. Because ultimately every witness is not a witness for one party or another. They're a witness for the coroner to help the coroner answer those 4 questions. So I put up on that slide the quote, which is from Lord Lane from a case over 40 years ago, but it's quite a good quote just at summarising what an inquest is and isn't. So if we could move on to the next slide, please. Thank you. In terms of how an inquest comes about, so the duty to report a death to the coroner is a duty not for you guys, it's for medical practitioners. And there are regulations. There's the Notification of Death Regulations 2019, and there's various circumstances in which a doctor is obliged to report a death to the coroner. Reporting it to the coroner doesn't by any means mean that it will end up as an inquest, and in fact the majority of deaths reported to the coroner for various reasons don't end up at an inquest, but some do. So having as a coroner, having been informed of a death, that will usually be because the person's body is in that coroner's area, and the coroner has a duty to investigate if the death has been violent or unnatural, the cause of death isn't known, or the person died whilst they were in custody or in some other form of state detention. An investigation, which is where the coroner starts, will usually, it will lead to an inquest unless investigations that the coroner undertakes lead to the conclusion that actually this person died of natural causes, in which case the investigation will be discontinued and there won't be an inquest. But unless that conclusion can be reached, then ultimately, if one of those criteria is met, the coroner opens an investigation and it will ultimately lead to an inquest. You might think that whether a cause of death is natural or not, which sometimes requires a post-mortem, but actually whether it's natural, you might think it's fairly straightforward. There is a kind of definition of natural. So it states that death is typically considered to be unnatural if it has not resulted entirely from a naturally occurring disease process running its natural course and where nothing else is implicated. But there is case law that goes back to a case in around about 2000 that I was actually involved in as a trainee. That's still quite an important case, because this case says that even if there is a death that on its face appears to be natural, so the medical cause of death may be natural, that death can effectively be considered unnatural if there's reason to suspect, and this is the phrase from the case, a culpable human failure, but for which the death would not have occurred. And so really the coroner will be looking, yes, at the medical cause of death, is it natural or not? But also, are there any concerns, any potential culpable failures that may have had a bearing on whether or not this person died? And if there's any kind of question about that, then ultimately it's likely to end up at an inquest. If we could move on to the next slide again, thank you. And probably on again, because that slide are the 4 questions that I've already mentioned are what the ultimate purpose of an inquest is. Some key features of an inquest. It's always worth remembering, if you do find yourself involved in an inquest, that the family is very much at the centre of the process. And I was told when I was very junior, when I first went to an inquest by one of my bosses, effectively, that it's in some ways it's a good idea to treat the inquest as an extension of a funeral, really, if the family is present. Obviously, it is a fact-finding inquiry and it is a court process, but it can be quite emotive and emotional. And it's worth bearing that in mind, but the family is put at the centre of it. I've already said that it's inquisitorial. It's a fact-finding inquiry as opposed to adversarial, where you have parties against each other. Ultimately, the coroner sets the scope of the inquest, and usually that will be confined to matters relevant in the sense that they may have caused or contributed. So relevant to that question of how the person came by their death. And as well as answering those 4 questions that I've already mentioned, then the inquest will ultimately, or the coroner will ultimately come to a conclusion, and I'll come back to that a little bit later on. Some inquests, and again, I think I'll come back to this briefly later, but it's quite legalistic and I can probably skim over it, but some inquests have a jury. Most inquests don't. But there's certain circumstances where there should be a jury, which would be between 7 and 11 people in the coroner's court. And if there is a jury, then they take over the job of the coroner in terms of determining the answers to those 4 questions and what happened and coming to a conclusion. But they do so with legal guidance from the coroner, really. If you end up attending an inquest, in a sense, in terms of your role, it won't make any difference whether there's a jury there or not, because the chances are if you have to attend, you'll be attending as a witness to give evidence, and I'll come back to that a little later. So if we could move on again, please. Continuing with the same thing, the key features. There aren't closing speeches like there are in a criminal court. And in fact, the rules don't allow the interested persons to make any speeches about the facts to the coroner. So at the end of the evidence, the coroner might receive some legal submissions, but those are strictly restricted to what conclusions are available to the coroner in that particular case, as opposed to long speeches about the facts, and that's not really a feature of an inquest. I mentioned that about civil and criminal liability, the coroner is not allowed to determine that. And because that's the case and nobody's on trial, there are rare circumstances where an individual might be asked a question where their answer might incriminate them. And if that were the case, then they should be given a warning. And there is what I've said there is the rule against self-incrimination, which really means you don't have to answer a question if the answer would incriminate you, i.e. you would effectively be admitting to a criminal offence. I've just mentioned that for completeness. I've only ever seen that happen once or twice in my entire career. I'm also going to skim over Article 2 and non-Article 2 inquests. I could spend an entire day and still not cover this topic. It's very legalistic, but what it means or what it relates to is the fact that, so it's Article 2 of the European Convention on Human Rights, which sets out the right to life. And as a signatory to the convention, the government is obliged to protect people's right to life in the UK. So they have certain obligations. They have an obligation not to take life unlawfully, and they have a more positive obligation to protect life, which really means either protecting the life where there's a known real immediate risk to a particular person's life, but also having in place general systems and duties that make sure that where the state has effectively taken on responsibility for looking after somebody, they're fulfilling their duties to look after them and to protect life. Now, the reason this is relevant is because quite often at inquests, families' representatives in particular might be arguing that an inquest should be an Article 2 inquest. And the reason for that is that where there's an Article 2 inquest, that question that the coroner has to answer of how the person came by their death gets widened to look at wider circumstances. And so it tends to be, well, sometimes actually in practical terms, the actual nature of the inquest is not really different, but the conclusions can be more critical, and the overall scope of the inquest can be wider. And so sometimes certain parties to an inquest will argue for that. And sometimes the Article 2 inquests tend to apply more where someone's died, for example, in prison. And even then, not all prison deaths, but where there may have been arguments about systems at the prison having failed that person. It's not confined to that, but I've just mentioned Article 2 inquests in case you were involved in an inquest where that was mentioned. And then I've gone on to say that because Article 2 inquests tend to arise much more where someone is in state detention, because if someone's in state detention, the state has taken on responsibility for looking after that person. But local authority care and Dole's orders, and there is a particular case on the Dole's orders front, say that they're not that doesn't mean that the person was automatically in state detention. I mean, obviously, I think if someone is subject to a section under the Mental Health Act, then that would ordinarily be considered that they are being detained as such by the state. But being subject to a Dole's order is not detention automatically, and certainly residing in some form of social care accommodation is not detention. It's just that that's where that person resides at the moment, albeit in practical terms there may be certain restrictions on their maybe physical ability restrictions, but restrictions on their ability to leave those premises, I suppose. But the relevance of that is to this Article 2 argument, which really I've probably spent too long on already. So if we could again move on to the next slide, please. Thank you. In context, and again, I'll go over this fairly quickly. The purpose of this slide was just to make clear that inquests will inquests will sometimes take place alongside other investigations. There may be other things going on. So there may be a professional body, the HCPC or the NMC or such a body conducting its own investigation, potentially. There may be civil claims for negligence. Depending on the circumstances, there may be a criminal investigation with the police involved. And of course, there may be other bodies such as the CQC involved and wanting to look into the same death that the coroner is looking into. So it's in context, it's worth remembering that the inquest may be maybe one of more than one set of proceedings about the same incident. And obviously, I'm going to come to the practicalities and the preparatory steps and so on of preparing for an inquest, but there's far more to it than just the strict legal side of it. There are all those potential human factors, the impact on your staff, morale. If there's any publicity, there may be an impact in terms of family members of other residents and their views about things, relationships with, I've said patients, residents, probably the better word, but there's obviously various human factors, and there's the stress for those involved in the inquest, for members of staff who might be called to give evidence as a witness. And then obviously that has a knock-on effect in terms of your organisation, whether that be financially, resourcing, having to deal with any HR issues that may arise, and regulatory involvement, as well as any internal investigation that you may feel you need to do into what's actually happened. So as I said, that slide is really just to emphasize that the inquest may not be the only thing going on, but I think in those circumstances, it's all the more important to have from the very beginning a consistent and coordinated approach in terms of how you respond to whatever investigations might be going on, including the coroner in terms of an inquest. And I think consistency is so important in those circumstances. If members of staff need to do witness statements, as a lawyer, I would always say I'd far prefer to have one statement that has gone out to various bodies than more than one, where there's always the risk of there being inconsistency between statements. And that can be difficult because, quite rightly, you may ask your members of staff to write out an initial account if something has happened. And that's quite right. And ultimately, that account probably won't become the main statement for an inquest. But consistency and coordination and just an awareness of the various investigations, I suppose, that may end up arising is important. So could we move on to the next slide? When a resident or one of your service users has died, you obviously need to consider whether your duty to notify the CQC is triggered. And really, that's probably the top of your list, is one of the first things you need to be considering. This talk isn't about that, but I've mentioned it because obviously it's important and not to be forgotten. And at the next slide, I'll just do a very brief reminder of CQC notification. But as I say, that's not the focus of today. In terms of the inquest, I do think providing support to all those involved from the very outset is important and likely ultimately to lead to a better outcome as far as your organisation may be concerned, in terms of your engagement with the inquest and what ultimately happens there. Understanding the process for everybody concerned is always going to help. Hopefully, this talk may go some small way to helping with that. But I do think, I don't doubt that being asked to provide a statement when something has happened that's involved a service user's death is stressful, and I think is important to provide support to colleagues. So the next slide, please, which, as I said, is about CQC notification. Just a brief reminder, under Regulation 16 of the CQC's registration regulations, you have to notify them of the death of a service user if that death occurred whilst services were being provided in the carrying out of regulated activity, or if it may have resulted from the carrying out of regulated activity. And that's obviously so that the CQC is notified of deaths of service users and can then, where relevant at least, and can then decide whether it needs to look into the matter further and take any action. That would, as I said, that would be completely separate. It's an entirely separate process from the inquest. There is, I mentioned overlap with the coronial process because there is a kind of understanding really between coroners and the CQC, and you should expect that the CQC would share with the coroner evidence that you provide to the CQC. And if they share it with the coroner and the coroner considers it relevant to an inquest that's going to be held, then I would expect that information, that evidence, to be shared with all the interested persons in the inquest itself, unless doing that would somehow cause difficulties, prejudice any enforcement action the CQC are taking. But I think you should work on the basis that whatever you provide to the CQC may also find its way to the coroner, because it may well be relevant evidence for an inquest, and if it is, that it would be shared with the interested persons in the inquest. And the coroner and the CQC may well liaise a little about progress. Certainly the CQC would inform the coroner. I would expect them to, if they take a decision not to prosecute somebody where they may have previously been considering it. The other thing to note is that there's no rule about who goes first. If there is a case where both the coroner and the CQC are looking into it, the order of play is not determined, and it could be that the CQC prosecute before an inquest takes place, or vice versa. We'll move on to the next slide, please. And this, I'm going to, again, I won't I'll go through it a little bit, but I won't dwell on it because I'm going to come back and list some of the kind of documents that you might expect to provide to the coroner when I get to the more practical aspects that I think will be of more use to you. This is really a list of the kind of issues, and quite a lot of them, but the kinds of issues in a social care context that from case to case, depending on the case, may be issues within an inquest. And documentation is at the top of the list for a reason. In terms of causing difficulties for you if you happen to be involved in an inquest, documentation, as is so often the case with any form of legal proceeding, documentation at that stage turns out to be rather crucial, and obviously very important. The coroner is likely to ask you for certain documents, which I'll come back to. But otherwise, as I say, I've listed a number of the kinds of issues, and it depends on the case, but the kind of issues that might arise in a coronial context. I'm not going to go through them one by one, so I'm keen to move on to some more practical advice. And as I say, to some extent, we will come back to that anyway. In terms of, sorry, if I could just move to the next slide. Oh, you have done supporting colleagues. So I've mentioned supporting colleagues. That slide just lists the kind of things that you can do to support your colleagues if they are called to an inquest or asked to provide a statement. And I do think it's so important to try and provide a good factual statement if asked to do so. So allowing time for a colleague to prepare a statement, providing them with relevant records and documents from the time is certainly likely to help them. And ask them if there's anything else that they feel they might need that would help them. I'll move on at this point then, please, to the next slide, which is entitled Preparation for an Inquest. So if or where the coroner has been notified of a death and the coroner's duty to investigate has arisen, and there hasn't been any post-mortem result or anything that confirms a natural cause of death, then it will proceed to an inquest. And that means the coroner will at that point open an inquest. And opening an inquest is really usually very brief. It's quite it's just a formal process whereby the coroner formally opens the proceedings and then usually adjourns in order to then undertake the various investigations, gather statements and documents, and so on. And so, as I've said, it's worth remembering, as I said on that slide there, an inquest is a formal process. There will potentially, in due course, be a timetable. It depends how complex the inquest is. Sometimes the coroner will have what's called a pre-inquest review hearing, which is really just to deal with administrative matters, what documents are needed, what statements are needed, when the coroner expects to receive those. Those should be really treated like a court order, and make sure that you're providing everything that has been requested and by the date requested, or at worst, contacting the coroner's office at the earliest opportunity if you can't do that, to explain why and seek some form of extension if that's what's needed. But the first thing I think might happen from your point of view, if there's going to be an inquest, is that you're contacted and asked for documents, records, and so on. And I think making sure that your records are well organised and are provided to the coroner in as well organised a way as possible is likely to assist you ultimately, and assist in the smooth running of the organisation, of the inquest. Ultimately, it depends what records the coroner asks for, but you'll be well aware there's all sorts of documents that you keep that may be relevant, whether that be risk assessments, just ongoing logs, not daily, nightly logs, care plans, support plans, medications records, nutrition, DOLS records. Any internal investigation reports would be expected, I think, to provide to the coroner. Also training records for staff, policies and procedures. There's all sorts of things that you may be asked for. You don't automatically need to provide all of these in every inquest. It rather depends what you're asked for, but they're the kinds of things you can expect to be asked for, depending on the inquest. And even as I had in one case, WhatsApp messages between members of staff. Rarely, but there was a particular reason why it became relevant in that case during the inquest itself. And my client, the care provider, was asked to provide the WhatsApp messages and had to do so. Statements. I'll move on to statements because I think as individuals who've been involved with somebody who sadly has gone on to die, this is perhaps the most important thing that you'll need to do, or one of the most important things. And I think it's so important to get statements right from the outset, because if you provide a detailed statement that's well written and makes sense and is consistent with records, then there is less chance that the coroner will want to call you to actually attend the inquest to give oral evidence. The coroner can read statements where they're uncontroversial and he or she doesn't have any questions to ask of that witness. So a good statement may be the difference between being called to the inquest and not. I quite regularly see statements that frankly are pretty poor. Sometimes they're illegible, really brief, don't contain relevant points. And as I said, the likelihood is that the coroner will just say they need a better statement and call you to give evidence at the inquest if that happens. Another thing about statements is statements for the coroner. If you remember that an inquest is a fact-finding inquiry, your statement should be factual and it should just address those matters that you had some involvement with. So what you did, why you did it. It shouldn't speculate about things, and it shouldn't speculate about what other people may have done unless it's relevant to your own decision making. So clear, typed if possible, consistent with records, and telling the story of your input with that person in a very factual way. And obviously to get that right takes a bit of time, which is why I was saying the support of providing time and relevant records is important. The coroner has powers under Schedule 5 of the Coroners and Justice Act, and they can, there's various powers, but essentially they can effectively summons individuals to attend court, summons individuals to produce documents, or serve what's called a Schedule 5 notice requiring the production of documents. And coroners have other powers. They actually have powers to enter premises and seize whatever they like, pretty much. But I've never known that happen, and usually that they would instruct the police to do that. But really, if you receive a Schedule 5 notice, it's very important that you comply with it in the appropriate timescale, because if not, the coroner has powers to impose fines for a failure, or it may ultimately amount to a contempt of court, which is a criminal offence. And the same applies to any witness summons you might receive. Sometimes organisations or individuals actually like to receive a witness summons if they know they're going to have to give evidence at the inquest anyway, because it just helps them in terms of their employer say, I have to attend court, and it's a reason. But usually people will understandably be a little bit nervous about receiving a summons, but it just means you're required to be at court to give evidence. And if you've provided a good statement, your statement will really be the framework for your evidence. So it's all part of your preparation for that. I've mentioned there, speak to the coroner's officer. If you become involved in an inquest and you're contacted by the coroner's office, having a good relationship with the coroner's officer, who are the kind of administrative assistants, as it were, quite experienced, many of them, and really good. But having a good relationship with the coroner's officer will probably be helpful to you. because they are your point of contact for any queries you have if you need a little bit more time for something. So as I say, it's worth having that relationship. If we move on to the next slide. There's a difference between being a witness, which means you had some kind of factual involvement and the coroner wants to know what your involvement was, and being an interested person, which I've mentioned previously. So there's a list of organisations or people who might be made by the coroner what's called an interested person. The most common one is where someone may have caused or contributed to the death, and therefore they naturally have an interest in the outcome and the proceedings. But there is a whole list. The CQC could be an interested person because they're an enforcing authority. And there's a whole list of people or organisations that can be. And ultimately, the coroner has a discretion to make anybody an interested person, but is not likely to do that for no reason at all. The relevance of being made an interested person. So if you're a care provider and your organisation is made an interested person, for example, or if as an individual you then get certain rights to be involved in the process that as a witness you don't. So if you are, quote, only a witness, your job is to give your evidence, and that's it. As an interested person, you can participate, really. You are entitled to have disclosure in advance of whatever evidence the coroner is going to be relying upon. You can be legally represented. And whether you're represented or not, you have a right to ask relevant questions of witnesses during the inquest itself, and at the end to make those fairly confined, if you wish to, legal submissions to the coroner. So that's what an interested person is, or an IP, or sometimes called PIPs, properly interested person. I've mentioned the possibility you may encounter a pre-inquest review hearing. And I'll skim over that quite quickly. I already mentioned it's really an administrative hearing for the coroner to get to grips with the evidence and preparatory steps for the inquest. Can be very useful. There'd usually be an agenda and some minutes produced afterwards. The coroner may give directions at that hearing, basically requiring you to provide documents or statements by a certain date. But if you are an interested person, then you can participate in that as well. So you would then be able to attend that hearing and speak to the coroner about the preparations for the inquest and the evidence and so on. So next slide, please. I've made the point there. I've already said about the fact as an interested person, you'll receive the evidence the coroner is relying on. And after the hearing, actually, you're entitled to a recording of the proceedings if for any reason you wish to have it. Do ask for disclosure. If you are contacted by the coroner's court and you're not sure what your status is, ring up the coroner's officer, have a chat, find out whether you're just witnesses or actually the coroner is intending or has made you an interested person. And if they have, ask for all the disclosure, all the statements so far, because you're entitled to that and it's useful to see what's there. If you're, again, quote, just a witness, then you just need to provide your factual evidence in a statement. I'm going to, because of shortness of time, I'm going to move on past the Worcestershire case. That's a bit legalistic and probably not really, I don't really need to go into it. And then if we move on again, so we're getting to the point of being actually what happens when you get to the inquest. So as I've said there, it's a public hearing. Any member of the public, including the press, can attend. There's very rare circumstances in which certain elements of it might not be public, but that is very rare. During COVID times, of course, lots of court hearings and inquests were no exception, started to allow more online attendance. And I think there's quite a variation now between coroners up and down the country as to the extent to which they will permit online attendance. And it's diminishing in time, essentially because I think most people would agree that seeing and hearing someone's evidence in person is always better than seeing and hearing it online. But depending on the circumstances, you may want to ask to be permitted to attend online. Again, you would do that via the coroner's officer. But do remember that if you're asked to attend an inquest to give evidence, the starting point, and you should assume that you're being required to attend in person. You don't have a right. Nobody has a right to attend online. That's a matter for the coroner. Whether you're attending in person or online, I would say treat it exactly the same. It's very easy sat at home on or in the office on a screen to forget that you are actually in a court and it's a court proceedings. So dress appropriately, and it's also important not to have other people, when you're giving evidence, not to have other people in the background. Unless the coroner has been made aware, it's very important that when you give evidence, it's your evidence and nobody else's. Bear with me one moment. I've mentioned already that some evidence can be read by the coroner if it's uncontroversial and nobody needs to ask that witness a question. So that may happen with some of the witnesses at an inquest, or all of it sometimes, in which case you won't be there anyway. And if you're an interested person, you can ask questions of the witnesses, usually after the coroner. Usually the coroner goes first, and then the interested persons get an opportunity to ask any questions. If you do ask questions, and this can be quite hard, they should be relevant to those questions, ultimately to how the person came by their death. But the coroner will assist you if you're not used to asking questions and you don't have a legal representative. And if you ask questions that are not relevant, the coroner will usually say so and try and guide you to ask a question that's allowed, as it were. So it's not something to worry about, but if you have an opportunity to ask questions, you might want to take that opportunity, and that's fine. It can be quite difficult if you're not used to asking questions in a court setting. Next slide, please. So again, for time purposes, I'll go over this pretty quickly. I may just move on, but it's there as a slide to give a number of tips as to, if you are attending online, all of the things to bear in mind. If you give evidence, you are either what's called affirmed, or you swear. I mean, you give evidence on oath, essentially. So you either give an oath on a holy book, and if you're doing that online, you need to have the holy book with you. If not, you can affirm. And as I say, there's just a list. Some of them are fairly obvious, but tips as to conduct, I suppose. If you're online, what will really irritate a coroner and cause real concern, and may cause the coroner to say, I want you to come to the court, is if you have someone wandering around, going in and out of doors in the background. There's other conversation in the background. That particularly if you're giving evidence, that will not go down particularly well. So that's that slide. The next one then is about the giving of evidence, and my tips, I suppose, about giving evidence. So, as I said, you'll give it on oath. You must tell the truth. It sounds obvious. If you don't, you're committing the criminal offence of perjury. But ultimately, my advice to anybody giving evidence in any setting has always been the same: give an honest answer to the question that has been asked. Even if you think that answer may not be best from your point of view in terms of your own position, if you try to evade the question, it will be obvious, and you'll come across as a far worse witness. So you're entitled to have your statement with you if you've provided a statement, which you usually will have done as an aide-memoire. And in the witness box, there will any documents that might be relevant in the inquest that the coroner is relying upon, they will be available to the witness when they're giving evidence. So if you need to refer to any records or care plans or risk assessments or anything at all, that is being considered as part of the inquest whilst you're giving evidence, do say so. Take your time, look at the documents you need to look at. Be prepared. It's not a memory game about what's in your statement, and ultimately what's in your statement is not your evidence. If you give oral evidence, your evidence is what you say in court. And in those circumstances, the statement will purely be a guide to the coroner and the interested persons about what you are likely to say. And your statement will have been provided to the interested persons in advance. So they will have read your statement, they'll have an idea of what you're going to say, but ultimately your evidence is what you actually say in answer to the questions you're asked when you're at court. And so it's worth preparing, read your statements. As I say, it's not a memory test of what you put in there, but if you've provided a statement that wasn't particularly good and then you arrive in court and start giving evidence that's fundamentally different from what was in your statement, I think you can expect to have a rather difficult time being asked about inconsistencies. So in advance, be aware of the kind of key issues that might arise for you. But general advice, listen to the question and make sure you understand it before you even embark on answering it. If you don't understand it, ask for it to be repeated. If the question is a question that can be answered yes or no, then answer it yes or no. Don't feel the need to fill silences or to garble and ramble on, essentially, because that will just lead to more and more questions and your evidence taking much longer than would otherwise be the case. And if the person wanted a bit more information after they've asked that question and you've given an answer of either yes or no, then they'll ask another question. But that's their job, not yours. So it's perfectly fine to answer yes or no if the question was a yes-no question. But it's fundamental to make sure you understand what the question is and then give an answer to that question, not something else. You may turn up to court with all sorts in your head that you want to say. And if at the end of the evidence you haven't covered something that you feel is important, you can do that. But I think it's important just to answer the question you're asked. There will quite often be gaps, usually because the person asking the questions is thinking about what to ask next. And it's quite tempting sometimes to fill those gaps yourself. But again, sit in silence and wait for the next question. And if you're able to, it's not easy, but if you're able to follow those rules, you won't go too far wrong. Understand the question, answer that question, give an honest answer, wait for the next question. And if you were asked something that actually is outside of your knowledge or expertise, don't try and speculate or guess, just say so. So that's my general advice about giving evidence.
Adam, can I just give you a time prompt? We've got 10 minutes, just without any time for questions. Thank you.
Yeah, sorry, I'm running a little bit slowly. So I'll try and move quickly on the remaining slides then. So the next slide, I'll just cover conclusions. Conclusions are the kind of things that you will probably have heard if you haven't been to an inquest. You'll have probably heard them when inquests have been reported in the press. So things such as natural causes or misadventure or accidental death or unlawful killing, they're what's called short form conclusions. They used to be referred to as verdicts, but conclusion is now the language that's used. That all conclusions, including unlawful killing or suicide, are now considered by the coroner, and the coroner's decision will be done on, it's called the standard of proof in legal terms, but on the balance of probabilities. So what probably happened, what is the more likely than not to have happened? And that's the basis for all findings and conclusions that the coroner can reach. So at the end of the inquest, the coroner will come back with some factual findings and probably summarize some of the evidence and make findings on any relevant issues, and then an ultimate conclusion. And as well as those short form conclusions, there can be what's called a narrative conclusion, which should be fairly brief, neutral, factual, tends to be more common in Article 2 inquests, but it is a conclusion that should summarize how this person came by their death briefly. And that will find its way onto what's called a record of inquest, which is the document that is always completed after every inquest. I've mentioned neglect briefly because I know sometimes you might be in a situation where you're concerned that there might be a finding of neglect. Neglect of itself is not a conclusion. It cannot be a conclusion legally, but it's sometimes added as what's called a rider, so alongside the conclusion. So you may have natural causes aggravated by neglect, or accidental death aggravated by neglect. And neglect is where there's been a gross failure to provide some really basic attention to somebody who was in a dependent position, and that has somehow caused or contributed to the death. So I just explain that because I know neglect is sometimes mentioned. So we'll move on to the next slide. The next, just have a look. Yeah, the next 3 slides are on the penultimate topic, I suppose. Prevention of future deaths reports, also known as Regulation 28 reports. So these are reports that the coroner might make after an inquest. And I know organisations are often concerned about receiving one. And these are reports. So the coroner has a duty to issue a PFD report if during the course of his or her investigation, information has come to light that the coroner considers gives rise to a risk of future deaths. And if there is a risk of future deaths and the coroner thinks that an organisation, usually an organisation, could be an individual, but usually an organisation, has it within their power to do something that would minimise that risk, then in those circumstances, the coroner has a duty to issue a report. The report goes to whichever organisation or organisations the coroner thinks has that ability to do something about it. The coroner cannot recommend what that person must do. All they can say is, I've received this information. It seems to me that there's a risk of ongoing deaths in these circumstances. I believe you have the power to do something about it. And then it's over to the recipient. If you as an organisation receive one of these reports, under the statute, you have 56 days to respond. The report itself will find its way onto the Chief Coroner's website. And if you want to have a look, you'll find over 4,000 such reports that are there that have accumulated to date of all types. Your response will also find its way ultimately onto the Chief Coroner's website. But it's very important that you probably seek advice, but respond to such a report if you receive one. Now, the thing about PFD reports is that sometimes the coroner will try and seek what will be referred to as PFD evidence at the inquest. Now, this is not evidence that is about how the person came by their death, so it's not relevant in that sense. But if you as an organisation have taken certain steps that have improved something that may ultimately have been a problem or have caused or contributed or been an issue in a case that has gone to an inquest, if you've taken positive steps, whether that be training or a change of a policy or a changing the way you do something, it is worth providing that evidence to the coroner in advance. And it may be the coroner will want to consider it at the inquest. And that may avoid a PFD report being sent to you. But my take on it is that even if you receive one, it shouldn't be, they're not meant to be punitive. It shouldn't be seen that way. It should be seen as an opportunity to try and improve systems and reassure the coroner that you've taken some steps that might in the future minimize the risk of something happening again, where in this case it's sadly had some bearing on somebody's death. I've mentioned on the next slide that this whole PFD process is ancillary. It's not strictly part of the inquest, and it's completely down to the coroner as to whether to receive PFD evidence. But as I say, as an organisation, if you've taken positive steps and made changes, I would suggest that you inform the coroner of that, perhaps in a separate statement. And then, sorry, I'll move on past the PFD slides to after the inquest. There's always learning. Well, there will more often than not be learning that can be taken away from an inquest. And I think it's worth having a debrief with the members of staff, learning what you can, even if it's just about the process itself. There may be follow-up issues that you feel you want to take. whether that relates to a PFD report or not. And as I said at the outset, there may be other investigations that have been ongoing all the time, or may be yet to commence. So they're worth they're things to consider after the inquest as well. I apologise for the fact I've overrun, because I wanted to invite questions if people have them. So perhaps I should do that rather than my case example. My case example was essentially an example of a care provider that I became involved at rather than the last minute in this inquest. They'd been made an interested person, but they had provided really, really good documentation from before I was involved to the coroner. There were about 1,700 pages, really well ordered. And in the end, that stood them in such excellent stead at the inquest, in terms of the family seemed to appreciate their involvement, and the coroner appreciates their involvement and made some very positive comments about them. And ultimately, the point of this case example, without going into the detail, is that it made my point of preparation and provision of good statements, and getting a grip on that at the very outset will help you through the process. It's also the case where we had to disclose the WhatsApps, which you can perhaps imagine that at the time that arose, we were rather concerned as to what informal comments there might be between members of staff on a WhatsApp group. Fortunately, even that just displayed that the members of staff concerned were really caring of the person they were looking after, and that was commented upon as well. But it's just a word of warning. Even WhatsApp messages between yourselves as members of staff could end up being disclosable in an inquest. So you need to be careful what might be in those. Apologies. I don't know how long you have in the sense of allowing any overrun, but I'd be very happy to deal with any questions I can. You're muted, Elizabeth.
Thank you, Adam. I've just ended the screen share to so I can see if there are any questions. I'll just check if there's anything in the chat as well. No, we have nothing in the chat. So before we conclude, any burning questions for Adam on what we've heard this morning? Anybody brave enough to want to ask away? No, it doesn't look like it at the moment, Adam. So as I said, we will send these slides out, so do make sure that we have your email address. If you've registered via the website, then we will have your email address. We will send out the slides. And Adam and I are working on a kind of a resource pack for you, which we will also circulate. So some of the hints and tips that Adam talked about, they'll be there as a record for you. And we will make this available to watch again. So just look out for the following on emails. And I hope you found it useful, Adam. I think it's a very interesting topic, and I think you have really took us through the process in a really concise, although it's a big subject, and within an hour it was a big ask, but thank you very much. I think what you have covered is really relevant and helpful for providers. So I'm just going to conclude everything now, and wish everybody a good rest of the day. And you know, keep a lookout. As I say, this is our first webinar. We've got lots more planned, so there'll be other topics coming your way throughout the year. And look forward to seeing you again soon. Many thanks, and as I say, have a good rest of the day.
Yeah, thank you very much.
Thank you.
Thank you.